What we are witnessing right now cannot honestly be described as a justice system operating in good faith. What exists today is a Department of Justice that has been hollowed out from within, reshaped, and repurposed into something barely recognizable. Instead of functioning as an independent institution committed to the rule of law, it increasingly resembles a refuge for individuals who could not survive in a professional, independent legal environment. Advancement is no longer tied to competence, ethics, or constitutional duty. It is tied to loyalty upward, not accountability outward. Survival within this structure depends on submission rather than skill, and the mission has shifted away from enforcing the Constitution toward actively undermining it. Yet even in this environment, the system has not completely collapsed. There are still individuals who function as a counterweight to this decay, people who continue to defend democratic norms, even when doing so places them squarely in the line of fire. In Minnesota, that resistance has become impossible to ignore. State leadership and independent judges are pushing back against what they view as clear federal overreach. The state's attorney general, for example, now finds himself under criminal investigation simply for performing the duties of his office. That fact alone should unsettle anyone who understands how a constitutional democracy is supposed to function. On Martin Luther King Jr. Day, residents of Minnesota woke up to news that the federal government had dramatically escalated its presence, sending roughly 1,500 additional active duty troops into Minneapolis to join the thousands already deployed. This escalation occurred despite clear evidence that local authorities were managing the situation. State and municipal law enforcement agencies, supported by the National Guard, had been handling protest activity with existing resources, even while absorbing heavy overtime costs. The real question was never whether Minnesota needed assistance. The real question was whether the federal government had any legal authority to impose itself in this way. Under the Constitution, active duty military forces cannot be deployed into American cities for domestic law enforcement unless the Insurrection Act is formally invoked. Without that step, such deployment is illegal. And if the act were to be invoked, Minnesota has made it clear that the move would be challenged immediately in court. The legal argument is straightforward. The deployment would be unnecessary, unjustified, and unconstitutional. Minnesota's National Guard is composed of local residents, neighbors, relatives, people who respond to floods, storms, and emergencies. They are not an occupying force. Federal troops, by contrast, represent a fundamentally different and far more dangerous escalation. Much of the unrest on the ground stems from federal immigration operations that have drawn large numbers of peaceful protesters. Protest is a constitutionally protected right, but crowd management still requires resources. Local police have been stretched thin responding to disruptions triggered by federal actions, which is why the governor authorized limited National Guard support. That decision is categorically different from placing active duty soldiers into civilian neighborhoods. Crossing that line would trigger immediate litigation. This pattern is not confined to Minnesota. Across the country, federal power is increasingly being applied selectively, not to investigate alleged misconduct by federal agents, but to target victims, journalists, local officials, and political opponents. In one deeply disturbing case, federal authorities launched an investigation into the widow of a woman killed during an immigration enforcement encounter, while the individual who fired the fatal shot faced no scrutiny at all. At the same time, investigations were opened into the city's mayor and the state's governor. The pattern is unmistakable. Everyone is investigated except the person responsible for the killing. The same Department of Justice authorized a search of a prominent investigative journalist who had developed an extensive network of whistleblowers inside the federal government. Her reporting exposed internal misconduct, mass firings, and alleged crimes. Federal agents seized her personal devices, cutting off communication with sources and sending a chilling message to anyone considering coming forward. This raid followed a wave of resignations within the Civil Rights Division, where attorneys reportedly concluded they could no longer operate ethically under current leadership. Against this backdrop, federal judges, many of them elderly, deeply experienced, and appointed decades ago by presidents of both parties, have increasingly become the last functional guardrails. In Massachusetts, a judge appointed during the Reagan era issued a remarkable ruling, stating openly that he had never witnessed such a coordinated effort by senior executive officials to violate the Constitution. He compared current government tactics to historical efforts to hunt down newly freed people and strip them of their rights. This was not rhetorical exaggeration. It was grounded in detailed factual findings presented in court. In California, another long-serving federal judge rejected an attempt by the Civil Rights Division to misuse federal law as a means of seizing private voter data from states. The Constitution deliberately assigns control of elections to the states to prevent exactly this kind of executive manipulation. The judge dismissed the case outright, calling it unconstitutional, unpatriotic, and aimed at voter suppression rather than election integrity. Back in Minnesota, a federal court issued an extraordinary order restricting immigration enforcement tactics against peaceful protesters. The judge found that constitutional protections against unlawful search and seizure had been violated and criticized the federal government for failing to present evidence. The ruling barred retaliation against peaceful demonstrators, prohibited arrests without probable cause, restricted the use of chemical agents and crowd control weapons, and clarified that simply observing federal operations does not justify detention. The fact that such fundamental principles had to be spelled out in a court order underscores how far enforcement practices have drifted from constitutional norms. Testimony in that case included accounts so disturbing that the judge acknowledged the difficulty of even reading them. These included stories of pregnant protesters being stunned and thrown to the ground, and individuals struck in the face by so-called non-lethal projectiles, resulting in permanent blindness. Under federal guidelines, any force directed above the neck is considered deadly force. These were not violent offenders. One victim weighed barely over 100 pounds. The punishment bore no relationship to any legitimate law enforcement objective. Despite mounting judicial rebukes, the federal response has not been restraint, but escalation. When courts intervene, the response has been to expand investigations, target additional victims, and double down on disputed narratives. Instead of examining whether federal agents committed civil rights violations, attention is redirected toward peaceful protesters, grieving families, and local officials. The logic of justice has been inverted, producing outcomes that feel surreal and deeply unsettling. Still, there are signs of resilience. In Virginia, voters recently delivered unified control of state government, and new leadership moved quickly to protect reproductive rights, voting access, health care, and fair representation. Proposed reforms are being placed directly on the ballot, reflecting a belief that democratic participation, not intimidation, is the appropriate response to federal overreach. Taken together, these developments reveal a single, unavoidable reality. The Department of Justice, as it is currently operating, has abandoned its historic role as an independent guardian of the Constitution. In its place stands a politicized instrument of power, increasingly restrained not from within, but by courts and states forced to defend themselves. The question now is no longer whether the system is under strain. It clearly is. The real question is whether the remaining safeguards will hold long enough for accountability to be restored. What makes this moment especially dangerous is not just the individual abuses of power, but the normalization of them. When extraordinary actions become routine, when emergency measures are treated as standard operating procedure, the public slowly loses its sense of what is acceptable. That erosion does not happen all at once. It happens case by case, ruling by ruling, investigation by investigation, until the exception becomes the rule. The federal government's current posture reflects that shift. Instead of responding to judicial criticism with restraint or course correction, the response has been to challenge the authority of the courts themselves. Arguments once considered fringe, claims that judges lack jurisdiction, that constitutional violations are not subject to remedy, that executive power cannot be meaningfully constrained, are now being asserted openly. These are not merely legal strategies. They are ideological positions that strike at the foundation of constitutional governance. Historically, the independence of the Department of Justice has been one of the most important stabilizing forces in American democracy. Presidents came and went, political winds shifted, but the department's core responsibility remained the same: to apply the law evenly without fear or favor. That independence was never perfect, but it was understood as essential. What has changed is not just behavior, but philosophy. The department is now being treated as an extension of executive will rather than a check on it. This is why state governments have increasingly become frontline defenders of constitutional rights. When federal enforcement mechanisms are weaponized, states are left with little choice but to step in. Attorneys general are filing lawsuits not out of partisan ambition, but out of necessity. Governors are asserting state authority not to provoke conflict, but to prevent unlawful federal intrusion. This is not how the system is meant to operate, but it is how it must operate when internal safeguards fail. The role of the judiciary, meanwhile, has become both more critical and more precarious. Judges are issuing rulings that should be uncontroversial, affirming basic rights, limiting excessive force, requiring probable cause. Yet these rulings are now framed by political actors as acts of defiance. The danger here is subtle, but profound. When judicial independence is portrayed as illegitimacy, the public is encouraged to distrust the very institution designed to protect them. We are also seeing the consequences of this shift in how information is treated. Journalists, once regarded as essential to accountability, are increasingly portrayed as adversaries. Whistleblowers are no longer seen as sources of oversight, but as targets of investigation. The message is clear: exposure will be punished, silence will be rewarded. That message does not need to be written into law to be effective. Fear alone is often enough. At the same time, federal enforcement actions are being carried out in ways that appear designed to provoke confrontation rather than resolve it. Heavily armed agents in military-style gear, aggressive crowd control tactics, and the use of chemical agents against peaceful protesters all contribute to a sense of intimidation. These tactics generate dramatic images, but they also escalate tensions and increase the likelihood of harm. When violence occurs, it is then used as justification for further escalation, creating a self-perpetuating cycle. This cycle depends on blurring distinctions between protest and disorder, between oversight and obstruction, between law enforcement and political enforcement. Once those lines are blurred, accountability becomes difficult. Responsibility is diffused, narratives compete, and truth becomes contested terrain. That is not accidental. Confusion is a feature, not a bug, of systems that benefit from unchecked power. Yet even under these conditions, public resistance has not disappeared. Voters continue to organize, to participate, and to demand accountability through lawful means. Courtrooms remain venues where evidence matters and where facts still have weight. State and local officials continue to assert their authority, even when doing so invites retaliation. These actions may seem fragmented, but collectively, they form a barrier against complete institutional collapse. What remains uncertain is whether that barrier will hold. Democracies do not usually fail because of a single dramatic event. They erode through sustained pressure, through fatigue, through the gradual acceptance of what once would have been unthinkable. The warning signs are not always sirens. Often they are court orders that should not have been necessary, investigations that target the wrong people, and institutions that no longer recognize their own purpose. This is the moment those patterns are becoming visible to anyone willing to look. The question is no longer whether power is being tested. It is whether the constitutional framework is strong enough and supported enough to withstand that test. Taken together, these developments reveal a single, unavoidable reality. The Department of Justice, as it is currently operating, has abandoned its historic role as an independent guardian of the Constitution. In its place stands a politicized instrument of power, increasingly restrained not from within, but by courts and states forced to defend themselves. The question now is no longer whether the system is under strain. It clearly is. The real question is whether the remaining safeguards will hold long enough for accountability to be restored.